My name's Will Travis. I'm the Executive President of Born Free, a member of the End Wildlife Crime Initiative, and just want to firstly welcome everyone to this event, filling the gaps in international wildlife law, the need for a global agreement on the illicit trafficking of wildlife. And I hope we have people from around the world joining us. It's early morning here in the UK and it's the evening over in Japan. The event is hosted by the Global Initiative to End Wildlife Crime, and we're very pleased to have a very high-level panel of experts to speak to us today. The initiative was founded by a group of people, John Scanlon, who will be speaking to us shortly, ADM Capital Foundation, the Global Environmental Institute, the International Conservation Caucus Foundation, and the Food and Land Use Coalition. It also has many champions around the world as well. I'd like to welcome you to this important session. We have, as I say, an outstanding panel of experts on today's webinar, and what I'll do is I'll introduce each of them more fully when they come to make their presentations. We're hoping that the video works because we have several who are making their presentations by video. Colleagues, the world seems only recently to have woken up to the spread and massively negative consequences of both the legal and illegal wildlife trade, environmental crime and ecocide, and the rapacious destruction of nature and our planet's remaining biodiversity, ecosystem services, and natural systems. These complex global-scale anthropocentric challenges that threaten the viability of much of life on Earth will not be resolved by one action or one agency alone. There is no magic bullet. They will require a comprehensive suite of urgent measures, including ecosystem protection and restoration, biodiversity conservation, a massive reduction in pollution, the end of ecocide, further and rapid efforts to address climate change, and investment in nature at a scale never seen before. Today, our session explores some of the possible measures that we can take in relatively short order: the establishment of a global agreement on tackling illicit wildlife trafficking through the development and implementation of a protocol under UNODC in order to better define and address illegal wildlife trade. Each of our expert panelists will speak for a few minutes, giving us their perspective and exploring the rationale for a wildlife crime protocol, and there will be several question and answer sessions. My colleague, Dr. Mark Jones, the head of policy at Born Free, which is hosting, will be curating questions which you're invited to submit throughout the presentation into the chat function, if you wouldn't mind. Put it in the chat function, and then I will try and point the right direction to the right person to get an answer on your behalf. What I'd like to do now is I'd like to introduce our first speaker, and that is John Scanlon. John served as Secretary General of CITES from 2010 to 2018, and in April of 2018 he joined African Parks as its first special envoy, and since June this last year he also served as the special advisor to the Elephant Protection Initiative Foundation, chair of the Global Initiative to End Wildlife Crime, and also chair of the UK Illegal Wildlife Trade Challenge Fund. In 2019, John was awarded the prestigious Officer of the Order of Australia for distinguished services to wildlife conservation and protection through roles with international organisations. And so I'm going to hand over to you, John, to get us going and give us that rationale for a global agreement on the illicit trafficking of wildlife. Thank you.
Thank you, Will, and thanks to your good team and our hard-working intern Alice for organising today's event, as well as to all our wonderful panellists for joining us today. And we're grateful for this opportunity to explore the benefits of a possible new, groundbreaking legal agreement on wildlife crime at such an important global event, the 14th UN Crime Congress. A few quick words on who we are. The Global Initiative to End Wildlife Crime, which was launched on the 5th of June last year, is an informal alliance of a diverse range of organisations and individuals coming from across every region who support its objectives. And we have two interrelated but not interdependent objectives, namely to encourage states to amend international wildlife trade laws to build public and animal health criteria into decision-making, and thereby institutionalising a One Health approach to wildlife trade, and to create a new international legal agreement on wildlife crime. And today's event is focused on a new wildlife crime agreement. So why do we say we need a new agreement on wildlife crime? Well, historically, many have seen tackling wildlife crimes as being about protecting endangered species, and in particular the charismatic ones. And while this is important, the critical need to end wildlife crime extends beyond a concern for the survival of a limited number of endangered species. We now know that these crimes are driving many species towards extinction, degrading entire ecosystems and their ability to sequester carbon, depriving governments of revenue, exacerbating corruption, insecurity and poverty, and they can pose a threat to public and animal health. According to the UNIPBS, over 1 million species will go extinct over the coming decades if we do not change course. And it describes 5 major threats to nature. Amongst them is overexploitation, including through illegal trade in wildlife. COVID-19 most likely had its origins in wildlife, as has previous pandemics. And the UNIPBS tells us that 1.7 million undiscovered viruses are thought to exist in wild animals, about half of which could spill over to people, including through illegal trade, markets and consumption. And while wildlife and wild nature-based climate solutions can offer about 1/3 of the carbon dioxide mitigation needed between now and 2030, the World Bank tells us that the illegal trade in fish, timber and other wildlife degrades ecosystems and their ability to mitigate climate change. Now, there are many UN reports, most particularly by the UNODC, that graphically describe the industrial scale and organised nature of illegal trade in wildlife, affecting between 6,000 to 7,000 of the species of wild animals and plants that are listed under CITES. According to the UNODC, these are crimes that exacerbate corruption, insecurity and poverty, and they affect every continent. And other sources put the value of illegal trade in CITES-listed species at about $20 billion annually. But CITES covers just 38,000 of the world's 8 million species. And if we consider all species, including fish and timber species, that are being trafficked, then the World Bank puts this figure closer to $200 billion a year. And if we include the cost of the impacts on ecosystems, then it is estimated at a staggering $1 to $2 trillion a year. Now, while we're focused on wildlife crime today, there's an increasing level of concern and attention being given to legal and unregulated trade in wild animals that could pose a risk to human health. And as such, we're seeing more and more local restrictions being placed on wildlife trade, markets and consumption that could pose such a risk. This trend towards stricter regulation is set to continue. However, if we are to avoid future pandemics, such high-risk activities must not simply move underground. And if we are to prevent this from happening, we must see a scaled-up collective enforcement effort. Colleagues, these are challenging, global, interconnected issues. Viruses can spill over in any country, and these highly destructive wildlife crimes are a scourge that affects every continent. A scaled-up, collective effort is needed to address them. Yet notwithstanding the destructive and high-risk nature of these crimes to both people and planet, there is no global agreement on wildlife crime, as there is, for example, on human trafficking. CITES has been heavily relied upon to date, but it was not designed to deal with wildlife crime. It's a trade-related, not a crime-related convention. And we've made best use of it, but we've stretched its mandate to the limit, and we now need to do much more. We need to address all species that are being trafficked, not just the limited number of species protected under CITES, and to embed both combating and preventing wildlife crime where it belongs, namely into the international criminal law framework. Our initiative is overseen by a steering group, and it's supported by a wonderful group of international champions coming from across every sector. And as well as we also have several special advisors, and they all support us pro bono. And this has enabled us to advance our objectives in rapid time. Last year, we released details on the possible form and content of the new Agreement on Wildlife Crime, which is now available in 7 languages. And we're indebted to the international law firm Arnold and Porter and several independent expert reviewers, including Dr. Tanya Wyatt, for their pro bono assistance in putting this draft together. Now, I'm just going to spend a few moments briefly outlining this draft protocol to help set the scene for subsequent speakers. Firstly, on form. The proposal is to create a protocol under the UN Convention Against Transnational Organised Crime, and the working draft has the title, The Protocol Against the Illicit Trafficking in Specimens of Wild Fauna and Flora. If adopted, this would be the 4th protocol to the UNCTOC, and it would be the first time that crimes that have a significant impact on the environment are specifically embedded into the international criminal law framework, signifying a powerful and unequivocal acknowledgement by states of preventing and combating these serious crimes in recognition of their devastating consequences. Secondly, on the content. The protocol has drawn upon the 3 existing protocols, as well as national legislation from countries including Australia, China, Mexico, Mozambique, as well as the UNODC guide on drafting legislation to combat wildlife crime. The protocol does several things, and if adopted, it would embed combating these crimes into the international criminal law framework. It would set out the conduct that is to be criminalised. It would apply to any species of wild fauna and flora, including fish and timber, that is protected under any international or any national law, and address the harvesting, taking, possessing, import or export, production from the sea of illicitly traded wildlife. It would make it a criminal offence to import any wildlife or wildlife product into a country if it has been acquired in prevention of the national laws of the source country, representing a remarkable expression of comity between nations and mutual respect for one another's laws. And the protocol doesn't just seek to combat these crimes, it also sets out commitments on collective efforts to prevent illicit trafficking in wildlife, including on raising public awareness, demand reduction and sharing information, such as on known groups active in illicit trafficking, on their concealment methods and known transport routes, and on the sharing of forensics. It also addresses the role and responsibilities of the carriers of contraband, the verification of documents, and training and technical assistance. And finally, it would automatically trigger all of the tools available under the UNCTOC. Colleagues, this is an excellent draft protocol, but it's still a working draft. And we do hope that it illustrates what is possible if states decide to adopt an international criminal law instrument that could capture what needs to be done collectively to both prevent and combat these highly destructive crimes. And if we get it right, the local communities living amongst wildlife and the governments of source countries, as well as our global biodiversity, climate, health and security, will all be the beneficiaries. The world's youth have the most to lose from the multiple crises we are confronting, and we owe it to them to do all we can to pass on a healthy and prosperous planet. We commend this draft protocol to you. Thank you.
John, you've set the scene, you've illustrated the scale of action that's needed, and you've given us the sense of urgency that we need. I'm now going to move on the Honourable Lee White, who's the Minister of Forests in Gabon. Professor Lee White has been Gabon's Minister of Forests, Seas and the Environment and Climate Plan since July 2019. Appointed as the head of Gabon's National Park Service in 2009, he's overseen the development of parks from a nascent parks authority with under 100 employees to a professional parks management agency with over 800 staff. Professor White is an honorary professor at the University of Stirling. He was awarded the CBE in 2011 for services to conservation in Central Africa. His career in the West and Central African Forest Belt spans 35 years, and as a scientist, he's published over 100 scientific articles and book chapters and authored and edited 15 books on the ecology and conservation of the African rainforest. So I'm hoping that we can hear from Minister White now.
Excellencies, ladies and gentlemen, it's a great pleasure to join you today for this UN Crime Congress event on filling the gaps in international wildlife law. Gabon has many natural treasures with magnificent marine and terrestrial biodiversity. Almost 90% of our land is covered in biodiverse, high-carbon tropical rainforests, and our ocean is equally rich. Our jungles are home to about 60% of the world's surviving forest elephants and over 20,000 gorillas, and our beaches host the largest breeding populations of leatherback and olive ridley marine turtles. Gabon has created a network of marine and terrestrial protected areas covering 21% of our land and 27% of our ocean. We aim to manage and protect these assets, which are the foundation of an economic model based on sustainable use and sound stewardship of natural resources. We are a member of the High Ambition Coalition for People and Nature, which aims for 30% protection on land and sea by 2030. But our natural assets are put at grave risk by transnational, organized criminal groups that seek to profit from illegally exploiting our precious marine and terrestrial wildlife at the expense of local people and the prosperity, indeed ultimately the stability, of the Gabonese state. Between 2006 and 2013, we lost 25,000 elephants to transnational ivory poachers. And despite vastly expanding our marine protected area network, we are still battling pirate fishing boats that penetrate our waters to steal the fish resources that are critical both for food security and diversification of our economy. Gabon is not new to the international debate about wildlife crime. Over the past decade, we co-chaired the UN Group of Friends on Poaching and Illicit Wildlife Trafficking with Germany, co-hosting side events on poaching and illicit wildlife trafficking at the UN headquarters, and co-sponsoring the first ever UN General Assembly resolution on tackling illicit trafficking in wildlife. His Excellency President Ali Bongo has been active on these issues since taking office. He is a founding signatory of the Elephant Protection Initiative and participated in global conferences on illegal wildlife trade in both London and Kasane. Ladies and gentlemen, while we have made some progress in tackling wildlife crime over the past decade, it is clearly not enough. If we are to succeed, we need to seriously scale up the fight against transnational organized criminals who are stripping countries bare of their precious wildlife. We are advised that there are hundreds of thousands of viruses in wild animals that could spill over to humans. We are struggling to combat wildlife change. We are advised that there are hundreds of thousands of viruses in wild animals that could spill over to humans. We are struggling to combat climate change. and staring down the loss of 1 million species over the coming decades in an ongoing extinction crisis, each of which pose massive risks to people and the planet, and all of which are exacerbated by wildlife crime. Furthermore, in some nations, wildlife criminal networks are a driver of instability. But they are all considered by many law enforcement agencies as a lesser crime compared to drugs, arms, and human trafficking, and we still struggle to develop effective collaboration with law enforcement authorities in nations that act as transit hubs or that are the final destination for illicitly trafficked wildlife originating in our country. We have still not fully embedded fighting wildlife crime into the international criminal law framework, and this failure reverberates through the system right down to the local level. We cannot stand by and watch wildlife crimes continue to escalate without ratcheting up our collective response, including to ensure that our international laws are up to the task. We owe it to the world's youth to act boldly and swiftly to ensure we pass on a healthy and prosperous planet. Adopting such a protocol would be the first time that a crime that has significant impact on the environment is specifically embedded into the international criminal law framework, and it would represent a powerful and unequivocal acknowledgement by states of the importance of preventing and combating these serious crimes. Gabon reaches out to all states to join the battle to end wildlife crime, which will serve to protect biodiversity, fight climate change, prevent future pandemics, and most importantly, ensure that the benefits of our respective nations' wildlife flow to local communities and the governments of source states and not to transnational organized criminals. Gabon welcomes today's event and the support of the global initiative to end wildlife crime in addressing this serious gap in the international legal framework. Thank you.
Next speaker who was going to be making a presentation by video, and that's Dr. Tanya Wyatt, who's been so instrumental in helping the work of the End Wildlife Crime Initiative move forward. I will, just so that you have it on the record, I will just explain who Dr. Tanya Wyatt is to everybody. Dr. Wyatt is a professor of criminology at Northumbria University in Newcastle in the United Kingdom. Her expertise is in wildlife trafficking, having written 3 books, with 2 further books due in 2021, and dozens of journal articles and book chapters on the subject. Much of her research focuses on the role of organized crime, corporate crime, and corruption in the perpetration of wildlife trafficking. She also investigates the overlooked element of non-human animal welfare and the human-centered nature of the illegal wildlife trade.
Thank you to Will and Mark and John Scanlon for the invitation to join this panel. Some of what I'm presenting today is a collaborative work of myself and my colleague Angus Nurse from the University of Middlesex in the UK. My argument for a 4th protocol is twofold. First, I'll discuss the advantages of having wildlife trafficking being recognized internationally as a crime. Second, I'll outline the benefits for law enforcement of having this 4th protocol. Wildlife trafficking is a serious crime contributing to the depletion and extinction of species. CITES is the only international mechanism that currently attempts to address wildlife trafficking. Yet CITES does not require that violation of the convention be defined as crimes. So collecting, harvesting, killing, transporting, importing, exporting, possessing, etc., in breach of a party's national legislation transposing CITES is not necessarily a crime. So in the first instance, having a 4th protocol specifically about wildlife trafficking sends a clear message about its severity. This could have deterrence effects. Global recognition as one of the most serious forms of organized crime could be symbolically powerful, though this would have to be investigated further. Furthermore, as the only current mechanism for addressing wildlife trafficking, CITES is not up to the task of being a policing or a law enforcement agency. for the reason I have just said, but also because there are no requirements for the parties to have an enforcement authority. There is no obligation for the criminal justice system to be involved, though obviously there is a role for regulatory agencies like border and customs agents and officers. At present, in CITES parties, without enforcement authorities, which is 85 parties, so nearly half of them do not currently have enforcement authorities, ministries of environment, institutes of zoology, botanic gardens, and fisheries research centers are up against criminals who can be organized. Furthermore, nearly half of the parties have not fully implemented the convention as required, so the level of enforcement is nowhere near what it needs to be to begin with. CITES is a trade treaty, not environmental or wildlife law. A fourth protocol on wildlife trafficking presents the opportunity to bring the principles of wildlife law to bear to protect species. These include, but are not limited to, prohibition of acts which harm individual animals beyond a permitted level. As John Scanlon has said, this is beyond the mere 38,000 species listed in CITES, which is critical since 1 million species face extinction. Wildlife law also incorporates res nullius or res communis, implementing the public good and wildlife trust doctrines as argued by Angus Nurse and Keith Vincent, who's formerly a member of the UK Law Commission. A global crime needs a global legal response. Although the CITES Secretariat and the Standing Committee have the ability to sanction parties for non-compliance with the convention, this does not happen all that often, even though, as I said, nearly half of the parties have not implemented the required legislation. In addition, there are numerous other issues with compliance with CITES requirements: failure to submit annual reports that include the trade data, failure to submit the implementation reports that are biennial now that include updates about implementation. And several parties have actually never submitted these. There's also failure to submit illegal wildlife trade figures as has been required for the last few years. All of these data are critical to understanding the nature and the scope of wildlife trafficking and developing effective responses. It is not working to have a small staff of this convention overseeing state obligations that are in essence breaching international wildlife protection standards. And finally, in terms of defining, recognizing on an international scale wildlife trafficking as a crime, this gives the global community, particularly the legal and law enforcement communities, the chance to draft an up-to-date criminal definition of wildlife trafficking that takes into account modern forms of crime commission, such as online trafficking. Adopt measures aimed at reducing wildlife trafficking, not hindered by conflicts to uphold trade, and in a proposed draft by the End Wildlife Crime Initiative, obligations to reduce demand, which are critical and an excellent addition. Promote cooperation between state parties, particularly around information sharing, and protect wildlife and prevent the worst forms of their exploitation. In regards to the benefits to the criminal justice and law enforcement stakeholders of a protocol specifically, I suggest these stem from the obligations on the states who join. As I mentioned, wildlife trafficking under UNODC becomes a crime in all of the jurisdictions that ratify it, which for UNODC is more than have ratified CITES. Crimes in one nation are recognized under the proposed protocol, even if they aren't crimes in the nation that discovers them. Importantly, the crimes that enable wildlife trafficking also are required to be in the parties' legislation too. Money laundering, which we've been talking about for the last several years, then becomes a central element for parties to address, as does corruption and obstruction of justice. This is likely better in terms of corruption, which is absolutely central to the facilitation of wildlife trafficking, but only featured in a 2016 as a resolution in CITES and non-binding. The required addition of these crimes extends the tools available to law enforcement officials. Again, these kinds of discussions have been taking place for the last several years, but since these are obligations under UNODC protocols, this has the potential to operationalize them much more widely. In addition, UNODC protocols also make more concrete the cooperation between law enforcement agencies in different countries. This stemmed from requirements to have frameworks for extradition and mutual legal assistance. These more formal relationships can potentially combat corruption and possibly be more financially supported since UNODC has a budget. There are a variety of initiatives and programs that are supporting the training of wildlife law enforcement officials and trying to build capacity of CITES authorities, customs, forensics, and so forth. My sense from talking to those giving these trainings and seeing the different funding streams from the US, UK, and elsewhere is there is a lot of replication and waste in the current system. With a singular space where wildlife trafficking is defined, there is the potential to centralize or at least to utilize UNODC as the means of coordinating the training and assistance that is needed to combat wildlife trafficking. Thank you for joining us today, and I will now turn the discussion back to John.
I'm going to come to Anne-Aurora Bertrand, and let me introduce Anne-Aurora. So Anne-Aurora Bertrand has dedicated her career to public interest causes in the field of human rights and international justice, contributing to efforts to establish international mechanisms for ending impunity for the most serious crimes. She worked at the International Criminal Court for 15 years, providing legal advice, working on policy and operational matters, and specializing in judicial cooperation and external affairs. She joined the Wildlife Justice Commission as Director of External Affairs, where she is responsible for policy and multilateral work, and she was admitted to the bar in Paris, France in 2005 rather. So I'm going to pass over now to Anne-Aurora Bertrand for your presentation. Thank you.
The Doha Declaration recognizes trafficking in wildlife as an emerging form of crime and therefore of concern to the global community, and therefore encourage states to adopt effective measures to prevent and counter it. Unfortunately, since 2015, the situation has not improved, with criminals trading tons of animal products and thousands of animals at a time. As we all know, the crime is of industrial proportions, with the volume of products seized only being a small proportion of the volume of products successfully trafficked. I would like to illustrate the points with a graph showing seizure in pangolin scales from 2016 to 2019. So the graph shows the volume of seizures in the top 10 countries where they took place. As you can see, there's really an exponential increase in seizures over the years. And something else that you can see is that the prevalent route in 2008 and 2019, the prevalent route used by criminals started from Nigeria and went to Vietnam through Singapore. To be complete, I should tell you that the Wildlife Justice Commission investigators in 2020 were offered huge quantities of scales, which demonstrate first the continued availability, and second, the ongoing market demand despite COVID-19 related restrictions. So now, law enforcement cannot work on this problem in isolation. For example, how can a source country tackle a crime that is transnational in nature, if its investigations and therefore its understanding of the problem doesn't go beyond its border? So the instruments facilitating cooperation present in the UNODC, so the special investigative techniques, for example, or joint investigations, must be used now more than ever. And what we see, however, and unfortunately, is that the use of these tools remains the exception. Let me present to you quickly another case on which we work post-2015. So how you can see on the picture, you can see elephant ivory here in a container. It was a huge seizure at the time, 7.2 tons of ivory. The ivory was hidden behind frozen seafood, and it was celebrated as a huge success. But what we can say also is that unfortunately it was also a missed opportunity. The two states involved at this stage of the trade did not manage to work successfully together, so they did not conduct, for example, controlled delivery. And although 3 persons were arrested in the shipping company, no conviction took place. And the result is that, unfortunately, this criminal network was not impacted as it should have. So now, how can a global agreement on wildlife trafficking assist in these circumstances? So first of all, we'll talk about the seriousness of the offense. The reason we're here today is that there's currently no international instrument dealing with wildlife crime. The adoption of such an instrument would allow us to shed light on the problem, would make it a policy priority in the countries concerned, and would really assist us in raising awareness among the law enforcement agencies that will have to deal with this problem. It would also hopefully result in more resources being allocated to them. In addition, such agreement could create a momentum to tackle these crimes before entire species are wiped out. As the former UN Special Rapporteur on Trafficking of Persons, Mrs. Gozzoli-Zilo stressed, the adoption of the first protocol galvanized the global movement against human trafficking. And we can only hope that the adoption of an agreement on wildlife trafficking will have the same effect. Second of all, a universal protection against wildlife trafficking would address and prevent impunity gaps and forum shopping. As we all know, criminals would elect to do their business in countries where law enforcement is weak or where the legislation are a bit more friendly to them. And to illustrate this point of convergence of crime, so that the criminals move where business is easier to do, I'd like to share another case. As you can see on the picture here, you see a workshop where ivory is being worked on. So it's ivory carving. What is remarkable from this case is that what is remarkable from this case is that in this country where we find this workshop, there was no domestic ivory market before, and we believe that the market moved to this country because the neighboring countries took stronger law enforcement measures, and also we believe that the Chinese ivory ban had this impact. What is also remarkable is, as you can see, that the production of the ivory carving is automated. So it shows you again the scale of the trafficking we're talking about. So hopefully, if we have a protocol, would have a criminalization of wildlife crime in many countries that would make it very risky for criminals to do business anywhere, and would avoid this phenomenon of crime displacement. Now, maybe I'm a bit late, so I will go quickly on the wide definition. John mentioned it. It's very useful because it provides more opportunities for law enforcement agencies to prosecute cases with transnational ramifications. I'd like to talk quickly about the judicialization of the protection. So the process of judicialization of the crime would make the protection of species less dependent, ideally independent from trade, commercial, and therefore political considerations. So the responsibility for protecting the protected species would fall upon law enforcement agencies. If we do this, we have to think of 2 steps to take at the same time, and that's the same for other crimes. First, we need to provide adequate assistance to the state to be able to take upon this new responsibility. So in terms of implementing legislations, but also technical assistance, and that's foreseen in a protocol, but of course it would be the role of the UNODC Secretariat, and they've been doing it for the other transnational organized crime in the UNTOC and in the protocol, and also enforcement of the legislation. It's one thing to have the legislation, but of course you want it to be used, you want it to be enforced. At least the criminalization of wildlife trafficking would have the advantage of positioning this crime at the same level as others. It would provide also more ammunition for the local actors to follow up on enforcement. Finally, interstate cooperation. So that would definitely help to have a protocol on this issue. The criminalization of wildlife trafficking in the national legislation of source, transit, destination countries will assist or will facilitate requests for legal assistance between them. And a common definition will also assist states in using the mechanism already foreseen in the UNTOC to allow and facilitate cross-border operations. In conclusion, we saw that the Kyoto resolution that I think was adopted today encourages states to once again to take effective measures to prevent and counter crimes such as wildlife trafficking. The adoption of a protocol on wildlife trafficking will allow states to agree on specific measures to strengthen their efforts and anchor these efforts in one common legal framework. As discussed, a common understanding of the problem is essential and will help create a stronger community committed to fight wildlife trafficking. Thank you.
Anna, that's extremely helpful and helps add more granularity to our discussions. And I take on board that sort of almost final point that you make, which is that the Kyoto resolution calls for action to be taken, and the fourth protocol is part of the action that we need. Because our time is a little short, and I don't want to miss anybody, I'm going to move straight on to Daniel Kashorais and his presentation. Daniel joined Sea Shepherd Legal as a senior policy specialist in April 2020. A scientist by training, Daniel previously served in several roles at the interface between science, policy and law, including as the first marine species officer of the Secretariat at the Convention on International Trade in Endangered Species, CITES, from 2015 to 2020. And so without further ado, I'm going to give the floor to you, Daniel, for your presentation. Thank you very much.
Thank you. It's a really great pleasure to speak at this event and share Sea Shepherd Legal's thoughts on the IUU fishing angle on the proposed wildlife protocol. Before starting, I just wanted to give you a very quick overview of what we do at Sea Shepherd Legal. We're a non-profit public interest environmental law firm specialized in the protection of marine wildlife, and we have a team of attorneys and policy specialists supported by experts and other partners, for example, in academia. And we work very closely with governments through the basis of MOUs to assist them in building stronger and more effective policies and laws and train officials in their implementation and enforcement. As John mentioned, the illegal taking and trade in fish is a great threat. And estimates of the value of IUU fishing, that subcomponent, are very hard to come by. As a 2017 estimate by the World Bank, that the total value of illegal fishing is at 11 to 36 billion US dollars. There's some issues with that estimate. It looks like they have conflated all of illegal, unreported, and unregulated fishing in some of those numbers. There's also a 2020 estimate that the revenue of illicit trade in fish products alone is 9 to 17 billion US dollars. And it's a bit hard to come by those estimates because there's really no great definition of IUU fishing. When looking at the Food and Agriculture Organization's International Plan of Action on IUU fishing, it's interesting to note that the definitions only include activities that run in some way counter to international obligations that a state has already entered into. So these activities for sure take place outside established legal and management frameworks, and they make it harder to achieve effective management. At the very least, this is due to missing data, but IUU fishing also includes activities with an outsized environmental impact or activities targeting protected species or violating temporal or spatial closures. Now, having established that all IUU fishing is undesirable, it's important to highlight that by definition, not all IUU fishing is illegal. If a specific activity is illegal, will usually depend on the applicable national legislation. The actors behind such illegal fishing are often professional and well organized, and they operate across multiple jurisdictions. As we all know here, countering transnational organized crime like this requires international cooperation, and there are several relevant agreements. I'll just name a few in the interest of time. So, of course, UNTOC is the principal global legal instrument to promote cooperation to prevent and combat the scourge of transnational organized crime. But as we have heard from previous speakers, it currently does not contain provisions that are specific to wildlife crime, let alone fisheries. CITES, one could say, is almost the opposite. It has a mandate to regulate international trade in some species of wild fauna and flora, but it doesn't have a direct mandate to address wildlife crime, as John said previously. Nevertheless, it has played a very important role, was recognized in multiple General Assembly resolutions. The UNODC Wildlife Crime Report says CITES sets the rules that criminals try to avoid, and CITES has also co-founded the International Consortium on the Combating of Wildlife Crime, ICRIC, which is composed of CITES, Interpol, UNODC, the World Bank, and the World Customs Organization. Last but not least, the 2016 FAO Port State Measures Agreement is the first binding instrument that specifically targets IUU fishing, and it aims to establish effective port control and eliminate ports of convenience. And the potential of this is great, but its effectiveness relies to some degree on regional and global coverage, and in our view, it will always benefit from complementary approaches, in particular approaches at sea. The proposed fourth protocol to UNTOC presents an opportunity for parties to extend the applicability of UNTOC to a broader range of IUU fishing activities, and it may help close some gaps in the current frameworks and add teeth to some relevant international frameworks, and as Aurora said, maybe galvanize some international coalition around this. Going forward, I would like to point out a few key elements of the draft that make it applicable to IUU fishing. And I just want to say, Sea Shepherd Legal fully recognizes that the decision to adopt the protocol lies, of course, completely with the parties to UNTOC. So, to start off, fish are an often forgotten component of wildlife, and in some countries not even included in the definition of wildlife. And Professor Wyatt may have shared some thoughts on that. She's recently completed a piece of work that analyzes this, among other things. It's therefore all the more noteworthy that footnote 20 in Article 3 of the draft protocol explicitly says that wild fauna and flora, the term used throughout the protocol, includes fish. The second really important drafting choice to point out and highlight is that Article 3 in the definition of trafficking includes introduction from the sea, and John mentioned that earlier as well. So, what is introduction from the sea? It is one of the 4 transactions defined as trade under CITES, and it refers to the transportation of a specimen from what we would now call the high seas into the territory of a state. It was operationalized by CITES parties in 2013 as follows. This is a graphical representation of Resolution 14.6 RevCop 16, and basically the normal situation on top is that a vessel from flag state A catches a specimen in its own EEZ and then lands the specimen in another port, in the port of another country. And this would be a normal export. In the middle and at the bottom, however, the vessel of flag state A obtains the specimens on the high seas, so outside of national jurisdiction, and then lands them either at home, that's the bottom, or it lands it in another state, that is the middle. And while those scenarios require different documentation under CITES, they're handled differently under CITES, they both fall under introduction from the sea as it is defined in the convention text itself. And given that all fish, in order to be commercialized, have to be landed somewhere, including introduction from the sea in the scope of the protocol basically extends its scope to all fishing activities on the high seas, which is a pretty broad scope. Now, having established that, let's talk about how the protocol can support other mandates. One potential stumbling block for making the most use of sort of mutually supportive mandates, where mandates overlap in international instruments, is often to what degree they are transcribed into national law. So CITES legal acquisition findings, for example, make explicit reference to specimens obtained not in contravention of national laws, focuses on national laws. And some international instruments, unfortunately, have a relatively poor track record of being transcribed into those national laws and would therefore not be taken into account. The draft protocol's direct reference to international laws in Article 5 here represents a significant evolution that has the potential to help address non-compliance with a lot of relevant international instruments that currently lack their own compliance mechanisms and that have a poor track record of being transcribed. Subparagraph B of Article 5 here gives also port and transit states an additional legal basis to take action against vessels involved in IUU fishing or transport of specimens derived from IUU fishing. And as John said, that shifts part of the enforcement burden away from source countries and to transit and destination countries. Before concluding, I also wanted to offer a few thoughts on things that would be useful to consider going forward with the drafting. So, as some of you may know, Article 73.3 of UNCLOS places restrictions on the use of corporal punishment by the coastal state for IUU fishing violations in the EZ of that coastal state. And under very specific circumstances, that would have to be taken into account by countries in implementing the draft protocol. But there's a number of ways around that. The protocol forgoes UNTOC's requirement that the crime must be punishable by a maximum of at least 4 years in prison to be considered serious. And that makes a lot of sense given that fisheries crime and other environmental crimes often attract comparatively low penalties. But parties may wish to include other criteria for prioritization, for example, based on environmental damage. Moving on to the third point, I also want to note that work on wildlife crime often has a terrestrial focus and audience, and for the draft protocol to be able to improve coordination of IUU fishing, the fisheries sector really needs to know that this process is relevant to them. They need to be involved and they need to feel some ownership of the process early on. Lastly, we note that the role of civil society in addressing illegal wildlife trade has evolved significantly from purely awareness raising, as reflected in UNTOC, to include a variety of support to state-led law enforcement. And the draft protocol takes a step in the direction of modernizing this in Article 7.3, where it says policies and programs and other measures should include cooperation with civil society as appropriate. But we still think that this limited scope may not do full justice to the variety of roles that civil society can and is already playing in fighting IUU fishing. And parties may wish to consider sort of more broadly to take the opportunity of the draft to move from multinational to multi-stakeholder approaches to combating wildlife crime. That's it from my side. I'm looking forward to questions and comments, and thank you very much.
Thank you very much indeed, Daniel. That's very helpful indeed, reminding us how important the protocol is in supporting other mandates, and that the development of this protocol in what is a very complex legal landscape could have a very positive impact at a national level in source transit and destination countries. I'm going to remind people who are tuned into this webinar that, of course, please do put any questions you have into the chat function, and then we will come to questions in due course. But now it's my pleasure to introduce our next panelist, Jorge Cayu. Jorge is the founder and current president of the Peruvian Society for Environmental Law, the SPDA. He was born in Lima, Peru. As an environmental lawyer, he's participated widely in drafting national and international legislation through IUCN, SPDA, and other institutions. He is currently promoting the development of the so-called B Corps and the B movement as president of Sistema B in Peru, including the legal recognition of the benefit corporations throughout Latin America. And so, Jorge, may I give the floor to you, please?
Hello, my name is Jorge Cayo from Peru. I'm president of the Peruvian Society for Environmental Law. And I would like to share with you why, from the perspective of Latin America, we support the adoption of the protocol on the illegal trafficking under UNTOC or UNTOC. Wildlife trafficking in Latin America is increasing. We have to realize that Latin America and the Caribbean have 41% of the bird species and 35% of the fish species of the world. And in terms of biodiversity, we have like 40% of representations of this biodiversity, 11 of the 14 terrestrial biomas. Keynote species well known worldwide, the Andean condor, the jaguar, are all under Appendix 1 of CITES, and these days, the data that we're having in the last year, from July to December of the 2020s, if we analyze what happened in enforcement of CITES in 4 countries, Ecuador, Peru, Colombia, and Bolivia, I can say that we have confiscated 197 species, about 1,742 live individuals confiscated, and most of them are birds, 41% of them, mammals, 31%, reptiles, 20%, and fishes, 7%. In the past, in the oceans, the data is horrible. 1,800 tons of shark fins were exported from Colombia, Panama, Costa Rica to Asia without being registered. For example, in the past 3 years in Peru, 20 million seahorses confiscated only in 2 operations in Peru. They were about to be exported to Asia again. So for my institution and for Latin America, and especially for Peru, it is crucial to be present in this effort to make UNTOC or UNTOC complement CITES efforts to help states to do more to stop wildlife trafficking and strengthen the rule of law and conservation of biodiversity and endangered species. CITES needs UNTOC to close the existing gaps. I know, we all know, that we are in the field, that the protocol will help national criminal provisions and procedures to tackle problems that are at our door, such as the actual pandemic and the ones that will come in relation with wildlife trafficking. So, wildlife trafficking as a transnational organized crime will be a key element to enhance and multiply strategies and techniques of judges and prosecutors. So the implementation of the protocol, as I am saying, will help also to implement this One Health approach and improve coordination between authorities responsible of wildlife and health issues. The problem needs to be addressed throughout the whole wildlife complex trade chain, including transnational organized crime. This proposal, I think, comes naturally from the development of international environmental law and all the dispositions and treaties regarding the legal trafficking of persons and other issues and other beings. So finally, to be short, we are very confident that the proposal of the protocol, it's not only well written and designed, but it makes sense in this century and in this moment of history of the global community, that we need to really convince all the economic agents, legal and illegal, that it's so necessary to close the gaps and to respect nature and ecosystems for to assure sustainable development and to enforce the laws, the existing laws. So thank you very much, and I hope that we can all help also Latin Americans to conserve and take care of our natural patrimony. Bye-bye. Thank you.
So our next presenter is Jinwei Zhong. Ms. Jinwei Zhong is an investment, trade and environment program officer at the Global Environmental Institute, GEI. Since coming on board in 2015, Jinwei has researched extensively on China's engagement in international environmental affairs, focusing on topics of combating illicit wildlife trade, forestry governance, as well as NGO development. On combating illicit wildlife trade, Jinwei, together with the GEI team, has carried out a series of studies on legislation, policies, environmental actions, both in China and other supply chains, including Cameroon, the Republic of Congo, Myanmar, Cambodia, and more, leading to the facilitation of dialogues and cooperation at national, subnational, and community levels. And I'm hoping that you're there, Jinwei, as I'm going to hand the floor over to you.
Again, my name is Jinwei from Global Environmental Institute. We are a China-based environmental NGO working on a range of issues that concerns China's presence in the global environmental arena. I am trying to put up my PowerPoint slides right now. Yes, and then on the issue of international wildlife trade, we have taken a supply chain perspective by facilitating bilateral cooperation between China and a number of other countries, including Myanmar, Cambodia, as well as Cameroon and Republic of the Congo in Africa. And it is my great honor to speak today from a Chinese NGO perspective on the needs and benefits of filling the gaps in international wildlife laws. So over the past few decades, China has increasingly become an important country in the global fight against international wildlife trafficking. And from time to time, with the efforts from the government, academics, NGOs, as well as the international society, a series of policies and initiatives have been put in place to address the issue, from imposing bans on the trade of tiger bone, rhino horn, and ivory, to the strengthening of enforcement actions, both domestically and internationally. So domestic actions here include the establishment of an interministerial meeting mechanism between various agencies to combat illegal wildlife trade, and internationally, the COBRA enforcement operations between 2013 and 2015 was with China's lead and participation. Also, I would like to mention that there was the inclusion of illegal wildlife trafficking provisions into China's criminal law, which allows for serious punishment to wildlife traffickers. And the year of 2020 was considered an important year for China on wildlife management, as the government took more rigorous measures to control the illicit use and trade of wildlife as part of the response to the COVID-19 pandemic. Taking precautionary measures, there was the decision to completely prohibit the eating of wildlife. The wildlife protection law is also in the process of revision, and in the draft version for public comments released in November last year, there was substantial revision in the law, which added the prevention of public health risks as one of the principles of the law. It also strengthened the interministerial coordination to include a broader range of ministries and agencies in charge of market control, logistics, transportation, etc., which are sectors that wildlife traffickers may take advantage of. Pangolins, as one of the most endangered wildlife species due to poaching and trafficking, has been upgraded to the highest degree of protection according to the list of nationally important wildlife species. Pangolins have also been removed from the Chinese pharmacopoeia, which was widely applauded by the international society for addressing the demand on pangolins. There was also enhanced enforcement across the country based on these new policy updates, and the criminal law was once again updated on the penalties on illegal taking and trade of wildlife, which is considered one of the highest now around the world. So, of course, because of these policy updates and standards, we believe there needs to be close follow-up on the implementation and enforcement so as to ensure that these updated regulations are being followed. And while these domestic policies and practices have made a great leap, we believe it is time for China to also now improve the global commitment to tackle the transnational organized crimes that have been infiltrating the wildlife trafficking supply chain. As Anne Aurora was just introducing, individual seizures of wildlife trafficking in recent years have found increase in shipment sizes with large quantities. This is also true in cases involving China. And I want to show you one example of a cross-country enforcement operation that disrupted a wildlife trafficking syndicate with tons of ivory and pangolin scales being seized. And so the large shipment sizes, the complexity of logistics that might now include one or several transits in different countries, and also the strong networks, including a multitude of individuals involved, will make it extremely difficult to tackle transnational organized crimes on wildlife trafficking. And challenges on tackling transnational organized crimes on wildlife trafficking include that different countries may have different levels of strictness in the control and punishment on wildlife crimes. This will leave spaces for traffickers to transgress national laws when carrying out transnational trafficking. And experiences drawn from our past endeavors facilitating the combat against illegal timber trade between Myanmar and China, for example, have shown some positive impacts by forming bilateral cooperation on policies and enforcement. Still, we see limitations in the scope of bilateral cooperation, as now more than 2 countries might be involved in transnational wildlife crime. And it usually takes years of time to formalize such official cooperation. Also, past multilateral enforcement collaborations, such as the COBRA operation I have mentioned, have found to be effective, but they tend to be in short term and usually it's a one-time event. And moreover, the combat against wildlife trafficking requires not only the engagement of wildlife management authorities, but also a multitude of government agencies in charge of different aspects of the crime, including enforcement agencies, judicial system, market control administration, transportation and logistics management authorities. So China alone cannot tackle this issue by itself. And we really hope to see that all countries along the IWT supply chain would make illicit wildlife trafficking a serious crime, and that they all strictly prohibit the entry, exit, and possession of illegally harvested and traded wildlife products from anywhere. And in fact, my organization, Global Environmental Institute, we have been facilitating bilateral CITES cooperation between China and a number of countries, as I mentioned, and nevertheless, this process can still be very time-consuming, and we think China would be benefited from a global-wide protocol that could help China and countries along the supply chain to achieve convergence on legislation and provide a general framework for coordinated enforcement and judicial cooperation. The United Nations Convention Against Transnational Organized Crime, the UNODC, is the key piece of international legislation addressing organized crimes. And with already 190 states as parties to the convention, and with main participation of enforcement and judicial systems, it would be really beneficial to also have the combat against transnational wildlife trafficking be included under this framework. so that we can achieve the vision on the consistency and harmonization of legislation and penalties across the supply chain, and that countries could are able to carry out cross-border investigations, enforcement, and judicial cooperation under this framework. Thank you very much, and we very much look forward to exchanges and cooperation in the future.
Very much indeed, Jingwei. That's very interesting and important. Not only hearing you talk about the fact that China is taking such comprehensive legal and practical measures and introducing significant penalties in relation to illegal wildlife trafficking, pointing out the importance now of translating those measures into effective enforcement, but also your words about China's ambition to support global measures such as the Fourth Protocol, I think gives us great encouragement that we are moving in the right direction. To move now to Dr. Winnie Kiru. Now, unfortunately, there has been a sad loss of a very close friend, which has prevented Winnie from actually joining us in person today. But I'm delighted to say that Alice Pasqualato has kindly agreed to present Winnie's presentation for us. I will tell you who Winnie is, though, because these are her words. So Dr. Winnie Kiru is a senior technical advisor to the Elephant Protection Initiative Foundation. Dr. Kiru holds a PhD in biodiversity management with a focus on elephant conservation and management. And Dr. Kiru is a member of the African Elephant Specialist Group, as well as being a trustee of the Kenya Wildlife Research Training Institute and the Amboseli Trust for Elephants. She's a founder member of Women for the Environment Africa, that's WE Africa, and I'm very honored to count her as a good friend. So, Alice, if you would be kind enough to give us Winnie's presentation, I'd be most grateful. Thank you.
Perfect. Thank you very much, Will. And again, thank you very much to Dr. Winnie Kiru for providing us with such an important statement on the African continent today. We're all really sad that she won't be able to join us today, but it's my pleasure to deliver her words for her. So, at the entrance of Kenya Wildlife Service headquarters in Nairobi, Kenya, stands a monument to the fallen hero. Many men and women in Kenya and across Africa have lost their lives in defense of our continent's fauna and flora. I do not know of any monuments built to commemorate the fauna and flora that Africa has lost to illegal wildlife trade, and yet tons of wildlife products representing untold value of Africa's biodiversity resources are traded in the legal markets across the world every single day. I believe there should be really another monument built to remind the world of the communities across Africa that have lost lives, livelihoods, and dignity to illegal trade in wild species of fauna and flora. This trade has led to the militarization of wildlife conservation across Africa, the violence and brutality that has been visited upon communities in the war against poaching has left lasting physical and emotional wounds that have alienated African people from their wildlife heritage. As a woman in conservation, I am aware that women have been excluded from conservation practice and leadership because of the wildlife wars. And yet they have suffered greatly as their sons and husbands are killed in the front line as defenders of wildlife, or eliminated or incarcerated as suspected poachers, informers, or just helpless victims of a brutal war. In 2021, the wildlife trade received an unprecedented level of global attention. The role of the trade in the emergence and spread of the devastating coronavirus jolted the world. Scientific research indicates that COVID-19 is a zoonotic disease, very likely transmitted to humans from wildlife, with horseshoe bats suspected to be the reservoir host and pangolins the intermediate host. The interconnected nature of things has never been so clear. Our economies, our environment, and most importantly, our health and that of the animals that we share our world with are all connected. The world has started to ask questions about the role and adequacy of the UN Convention on International Trade in Endangered Species of World Fauna and Flora, CITES, in regulating legal and illegal wildlife trade and protecting us from the next pandemic. The Elephant Protection Initiative Foundation is delighted to be an international champion of the global initiative to end wildlife crime. The EIP works in Africa. We are a governmental organization with a membership of 21 states. We work closely with our members in the fight against illegal trade in ivory and rhino horn. And while we recognize the important work that has been done for CITES and other initiatives to combat the illegal wildlife trade, we know that this is not enough. Wildlife crime is serious crime and must be recognized as such. We need a new agreement on wildlife crime. We support the development of a fourth protocol on wildlife crime under the UN Convention Against Transnational Organized Crime, UNODC. This new protocol will embed combating wildlife crime into the international criminal law framework, apply to any species of wild fauna and flora protected under international and national laws, and make it a criminal offense to import any wildlife or wildlife product acquired in contravention of national laws of the source country. We welcome this development and pledge continued support to the global initiative to end wildlife crime. Thank you, Will.
Thank you very much, Alice, for making that presentation on behalf of Dr. Winnie Kiru. I'm sorry I couldn't hear it, so I can only assume that Winnie's words were thoughtful as ever, and she certainly is a voice that will become more powerful and more influential in the months and years ahead. I want to come finally to you, John, for sort of your summing up remarks, but I have a question that I hope you can help us understand. You know, you've talked, and our speakers have talked, all of them, in fact, have mentioned the issue of, implementation. And importantly, of course, with implementation, there is always a resource issue. And I wonder if you have any thoughts about how we can secure the resources necessary to bring about if the fourth protocol moves forward, if the changes within CITES that you talked about very early on come about, and then of course at national level as well, how can we secure the resources necessary to turn what is, frankly, a really brilliant idea into reality on the ground? And if you would also then just conclude with your final thoughts, John, I'd appreciate it.
Thank you very much. And yeah, it's a really good question, Will. Thanks for asking it. Resourcing is obviously a critically important issue. What we've tended to do historically is look at wildlife as a wildlife conservation issue, as about wild animals and wild plants, draw upon conservation agencies to generate the financing. That's going to have to fundamentally change if we're going to secure the resources we require in order to protect wildlife and all the benefits that flows from that. So what we need to do, and I think we are doing this collectively, is look at what are the real benefits of protecting wildlife that go beyond the benefits to the individual plants and animals themselves. And that's what we've been discussing today, because this is about protecting biodiversity and all of the ecosystem services it provides. It's about combating and adapting to climate change, the ability to mitigate, the ability to adapt. It's about preventing future wildlife-related pandemics. It's about security. It's about development and generating local jobs. These are all the benefits that flow from wildlife conservation. And as such, as the benefits are many and varied, so too must the sources of revenue. We need to see the health sector, the development sector, the security sector, and others invest in wildlife conservation, because the benefits from wildlife conservation flow to security, to climate, to health. So that's critically important. So we have to reframe the narrative around wildlife. And I do think that is starting to happen. I do tend to think that even more so than the link between nature conservation and climate change, this link to potential future pandemics is starting to shift thinking and starting to shift perceptions. So that's what we need to do, because unless we can attract more resourcing and attract more resourcing to these issues, we won't succeed. The other thing that's critically important, and Will, I know this is one close to your heart, is we have to see resourcing flow through to the local level, to local people. So if local communities living within and around wildlife are protecting that wildlife, and there are global benefits to biodiversity, climate, security, etc., then we need to see the financing coming from external sources to enable that to happen. Let me stop on the question there. Let me thank you, Will, for moderating today. Thank all of our colleagues who've presented. It was fantastic to hear Anne so logically set out the benefits of a protocol. Excellent to have Daniel give us this IUU fishing perspective. It's too often missed. There's a lot of focus on terrestrial. There's this huge importance of focusing on marine. That's what the fourth protocol we've drafted seeks to do. Daniel gave a compelling case as to why this is beneficial in terms of looking at the I part of IUU fishing in particular. It's a pity Winnie couldn't join us today. Will, you couldn't hear it, but it was a very powerful statement coming from Winnie from a Kenyan and an African perspective, which really was coming from the heart from Winnie. It was a wonderful presentation. And so we have had a wide array of presentations that have been complementary of one another, coming from very different perspectives, but all coming to the same conclusion, and that is that we are not doing enough at the moment if we're hoping to end wildlife crime and if we're hoping to prevent the next pandemic. And it's very clear from whichever perspective you take that we're going to need to scale up our effort. And from all of these different regions, from all of these different perspectives, we're converging on the same point. If we hope to end wildlife crime, if we hope to be able to prevent future wildlife-related pandemics, we need to do more. We need to embed this international criminal law framework. UNCTOC is the instrument. A protocol under UNCTOC would carry us forward in finally being able to bring this scourge of wildlife, illicit trafficking in wildlife to an end. So perhaps I'll pause there, Will, unless there's any other questions. Thanks to you, but big thanks to everyone who's participated today for fantastic presentations, and we'll make sure that the wealth of knowledge that's been shared today and the different perspectives are available in other formats as well. Thanks, Will.
John, and I mean, really, you've summed it up extremely well. I just can only add my thanks again to the team that put this together, Alice, Marta, Mark, and thanks to all our wonderful speakers. What I heard was inspirational and motivational. What I would say, in echoing your point that we are not doing enough, John, is that we simply cannot go business as usual. The world has changed. We must take advantage, if that's the right word, of this the sort of disaster that has confronted us over the last year or so, to think differently, to think more boldly, courageously, to do more, as you say. And I think what's been put forward by the End Wildlife Crime Initiative offers real practical tools in terms of moving the agenda forward, not incrementally, but in the kind of step change that we really need. So I would urge you, those of you listening to this, to please go to the End Wildlife Crime website. It's been put in the chat. That's www.endwildlifecrime.org. To find out more, that's where I'm sure we will be posting the videos from Professor Lee White and Professor Tanya White, and much more information that hopefully will inspire you to move towards a new and better future for both wildlife and humanity through better efforts to control and eliminate the illicit trafficking in wildlife. So I don't think there are any more questions. I want to conclude now, but thank you so much, everyone, for taking part in this event, and goodbye.